Baik, Assalamualaikum warahmatullahi wabarakatuh. Selamat sore, everyone. Good evening. Today we will join a guest lecture with Prof. Linen, and like we informed before that the topic of guest lecture is the comparative legal research between uh, the European continental tradition and also the common law tradition. And Pak Linen come here and will explain how the method, how to use the source to increase your capability regarding research. And we need approximately 2 hours, still start in 6 until 8 p.m. And Prof. Hawin now still in Makkah, so cannot join to class. And he expect that all of you enjoy this guest lecture and get the benefit from the guest lecture to increase your capability. Hello, he said. I think on behalf the study program is like that, and time is yours, Prof. Linen, to give us a perspective, to give us the method how to carry out the especially in comparative. Time is yours.
Uh, Thank you very much, Maskotib. Let me introduce myself first and explain why I'm the one talking other than I have a professor title. I was trained as a common law lawyer originally, studied in the United States and was in law practice, turned to university, but before I actually went into law practice, I spent a couple of years in a German academic institution, the Max Planck Institute of Criminal Law, doing sort of police and criminal law academic work, and then went back into law practice in the United States because it was our custom that you essentially not become a law professor, a law teacher, without having worked in practice for, say, 5 years. But what that means is originally I was trained in the common law, and then I spent several years in a civil law jurisdiction, doing mostly public law. And if you're familiar with the traditional, already hear the call to prayer, what I would suggest is we're going to interrupt for maybe 10 minutes and let people respond to the call to prayer, and then we'll resume in 10 minutes. I said, heard it in the background. So we'll take a 10-minute break and resume then. For those of you respond to the call to prayer.
Okay, so please, if you want to pray first, and we'll continue our discussion in at least 6 past 20. Okay, 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 please.
was telling you, um, I was first trained as a common law lawyer, and then I went on an academic fellowship after my original law study and spent a number of years in Germany and continued to work there on and off while, so that I spent a long time in one of the classic civil law jurisdictions, because the law jurisdictions were France and Germany. And then in the mid 1990s, I started doing work in India, which, technically speaking, if you were trying to describe this to a European, you would traditionally say the Dutch followed what they called Roman Dutch law, although they were on the civil law side heavily in French. But in the modern setting, they're much more influenced by German law, because when I've looked at things like this sort of administrative courts doctrine and the like that reaches back to the early 1990s, that's all German, nothing French there. So part of the problem is a practical matter. If we talk about civil law and common law, it helps to have been exposed to both in different systems. So you recognize some of the differences. And that brings us to a very basic question in terms of doing comparative legal research. Number one, how much comparative law in an academic sense you need to know to make sense of it, or do you just look at how people approach problems? And what I would like to do is first go through some structure and then talk about some examples. And that will take us through most of the time. I'm happy to answer questions, have some over. And then we're supposed to be joined by a colleague from a law librarian from my university, by the name of Becca Maxwell, who will come in second hour and do some Westlaw training. So let's go on that basis. And since it's a relatively schedule, talking about Okay. Thank you, Mascot. Um, and now comes the question, all right, how does this carry over into the modern world? One more thing. Now, of course, you have the traditional codes, but you now have modern statutes, particularly in areas like economic law. And there you find some differences. But before we talk about them, let's say something about sources on the common law side. As a matter of sort of legal history and approach, the common law is not rooted in Roman law, going back 1,000 years theoretically, even though it's really just the modern rediscovery. Instead, the common law is based upon judicial opinions traditionally, and the sort of leading common law jurisdiction originally was the United Kingdom, and then you see all the English colonies. So you have the United States, and you have Australia, and you have Singapore, and you actually have India too. So if you were to say, in the modern world, what is a common law jurisdiction and what is a civil law jurisdiction? It's mostly by former colonies. So what happens is the European jurisdictions, United Kingdom, Germany, France, were the ones who originally sort of produced these two approaches. But what you would find is most of the world in a modern setting tends to be more civil law oriented, simply because most of the world was colonized. Uh, but but it's different in the sense that you would see, for example, if you look at modern attempts to modernize law, the Chinese, for example, followed German law. To a certain extent, the Thais and at one time the Japanese also tended to, the Thais and the Germans also tended to kind of implement, um, let's say, German law, then the Koreans did. Um, the Vietnamese started with French law. So what happens is, if you talk about the continuing influence, of course, you had Dutch law for a while, but as I said, if you look at modern law, you would say the Dutch were referred to as heavily influenced by French law, but all the modern law I've seen, it's all German in terms of what they do now when they try to update statutes. Um, common law being based on judicial opinions is almost more a method than anything else. Technically speaking, the judicial opinions can all be changed through legislation. And in the modern setting, the modern economy is less complicated in the, let's say, in a common law jurisdiction than in a civil law jurisdiction. So in the modern setting, much of it is statutory. But nonetheless, what we do the entire first year in common law faculty is we try to train students to read opinions and sort of do the reasoning that judges traditionally do. And I've spent some time, for example, in German university, and what do they study in the first year? Well, they study things like jurisprudence and legal theory. So that people are trained very differently. Now, when we go to statutes, talk about modern law, the area that probably is most important, at least in practice, probably also in an academic setting, is economic law. And part of this is because look at the traditional civil law jurisdictions, they were more, economies were based on banking. The modern economy, or modern law in areas like capital markets and antitrust law comes out of a different tradition, because starting in the United Kingdom and in the United States, you had much more reliance on capital markets. So what happens is a lot of modern economic law, even if it's coming out of the sort of traditional leading civil law jurisdictions, actually comes out of the common law tradition in the form of statutes, for simply because, to the extent the Germans wanted to introduce more capital markets and stock antitrust law, for example, that you find in the EU treaty, because that was more grounded common law jurisdiction, economic law almost across the board tends to be more influenced by the common law jurisdiction, but it's all statutory with some regulation. Now, let's talk quickly about differences in certain areas, like in public law. The structure in the United States, for example, is we, of course, have a constitution. We have judicial review for constitutionality under the Constitution as a function of some decisions that were made relatively early in the 19th century by Supreme Court judges. Where does judicial review, for example, in why? Well, following most of the public law on the civil law side, there's a different view of separation of powers, and the classic view in a civil law jurisdiction is that it actually violates the separation of powers to have a court examine something that's done by legislature, and the change in that, in the modern setting, comes out of Germany after World War II, when they form a constitutional court. And as a result, you now have, of course, you have a constitutional court since, I guess, 2003. It was based at the time, people said, mostly on the Korean constitutional court model, but the Koreans borrowed it from the Germans. So essentially, you have inherited, the German idea of a constitutional court via Korea. For to say, however, are there any differences? Okay, now you have a constitutional court, there's theoretically judicial review. We won't get into, say, are the views, for example, in Germany and in the United States the same in terms of the role of the state and the position of the individual when you're talking about public law? And the answer would be no. And I'll give you an example out of modern practice. Essentially, it's now been popular to start looking towards bringing suits about climate change, questioning whether governments are doing enough to regulate, let's say, carbon emissions. And for example, there's a famous German case that you can read, because the Germans now also publish their constitutional court cases in English, in which essentially Germans said that the state owed a duty to not favor, let's say, older generations over younger generations, because what it was there was a challenge to a statute that was passed by the Bundestag that essentially sort of backloaded all the carbon reductions so that they didn't have to worry about it for 20 years, which was great if you were 60 years old because it was never going to affect you. But all the 20-year-olds said, wait a minute, we're the ones who are going to be responsible for solving the problems that were created by the 60-year-olds. And the German court said, no, no, no. The state owed a duty to sort of treat the different generations fairly, and therefore they required the Bundestag to sort of rewrite the statute to move some of the obligations forward, so the older generation had to sort of make difficult decisions. But here's the question. Was it just because it was fair or just? No, the answer is it was because, as a social democratic state, the Federal Republic of Germany believed the state owed a duty to its citizens to sort of support them. If you looked at, on the other hand, at the United States, we would say the state has a duty not to discriminate between citizens, but it doesn't necessarily have to support them. So the German idea in the Constitution is that the state actually owes a duty of sort of supporting and advancing people. In the United States, it's you just don't discriminate and treat people differently. Why does this matter? Well, it would be much harder to get a constitutional decision on climate change, because we would say, well, the Congress, our version of the DPR, can enact a statute to advance everyone's interests in terms of climate change, but there's no duty for them to do that. If they don't do that, we're not in the same position. So one of the problems is start talking about public law, you really have to understand what is of the basis and role of the state as compared to, let's say, one country or another, modern setting, based on the example, it leads to differing answers. Let's now start working our way through some examples, because this is all very interesting, but it's general. Let's talk about, I think I can now use one. Talk about, for these purposes, the problem of economic hardship. And as a doctrinal matter, it's treated differently. And I wanted to choose a private law topic so you'd see some of the differences. Has anyone read Professor Gautama on Indonesian contract law? What does, and I see only one of you nodded yes, and I know this is not UI, so you probably read Pakistan instead, but I think Professor Gautama wrote a series of books. Do you know what Professor Gautama says about changed circumstances, economic hardship? He refers to the doctrine of improvision, which is sort of a French law doctrine. And essentially, the difference in responding to economic hardship is that traditionally the common law takes a view, working from cases. The case that we would do is we would talk about two, but the hypothetical is, what happens when you sign a contract to sell a building, and then before the contract closes, the building burns down? Are you obligated to rebuild the building if you're the seller, so you can deliver on the contract? Or can you cancel the contract and say, building no longer exists, we're sorry, but we don't have to build a new building to replace the one that burned down? The view of economic hardship in the common law is that basically you require impossibility, and we would define impossible is if the subject of the contract is destroyed, building burns down, you simply rescind the contract because of impossibility. You can't sell something that's not there. And we would say theoretically, well, built a new building, it would be a different building anyway. But we would say, short of the subject of the contract being destroyed, you have to perform even if it's hard. Classic example for that is the British have something called the coronation cases. And what happens, as I think happens to the king, when they do a coronation, there's a parade through London. And what happened roughly 100 years ago is there was going to be a parade. I think it was for King Edward something, I forget the number. And on the day of the parade, of course, if you wanted to, you could rent a house on the street, but it would cost 10 or 20 times as much as the normal rental for the house. And the question, what happened is they announced the coronation, everyone goes out and spends enormous amounts of money on the house, and then the new king gets sick and delays the coronation for 2 months or something. And the question is, are the people who sign the contracts, the lease contracts on the property, required to pay the extremely high prices, rent, that they were only going to pay because of the coronation? But the problem is the contracts say nothing about the coronation. They just say on June 1st, 1910 or whatever the date was, we will rent this building for £1,000, even though otherwise you could rent the building for £500 a whole month. In our system, though, the idea is they had not specified that it had to do with the coronation. It was not a condition to the contract. The building was not destroyed, even though they wanted the building just to watch the coronation. So they had to pay the £1,000, even though it was, people would say, well, was it an act of God that the king became sick? Or our view is traditionally you have to perform short of impossibility. And impossibility in that case is not the building burned down. They could still rent the building. What was missing was the collateral circumstance of the coronation. But those are sort of the cases we learn. If you look, on the other hand, at French or German doctrine, I think inherited from France, according to Professor Gautama, the leading cases actually come out of the early 1900s. And they involve, for example, in France, during World War I or just before World War I, a private company signed a contract for street lighting. I believe it's with the city of Bordeaux, and it was gas street lighting. And what happens when you have a war? The price of energy goes up. Just happened in Ukraine conflict. And then the question is, if in fact it would cost 10, 15 times as much to perform on the contract because the price of gas has gone up that much, are you released from keeping the street lights on? Or you have to just buy the gas at 10 times the old price? The idea in the French case that I'm talking about was basically it was a public contract. They have public contract law in the civil law countries. And essentially they said, well, the purpose of the contract was actually sort of lighting the streets. And the fact is, if you simply said the company should bear the cost, well, the company would just declare bankruptcy and there would be dark street. So the French judge required adjustment of the contract, the sort of sharing of the burden in the city gas company. There are similar cases in Germany having to do with inflation in the 1920s. where someone signed a long-term lease, maybe in 1910, that you would pay 10 Reichsmarks a month for a building, or an apartment, or to rent a store. And then what happens, Germans lose World War I. They have very high inflation during the Weimar Republic. And so suddenly the 10 Reichsmarks a month are worth maybe 1/10,000th of what they were in 1910. The question then becomes, are you supposed to readjust the rent, the value of the, in gold, for example, of the Reichsmarks in 1910, carried forward to their value in 1920 or 1925? And the Germans adopt a similar view than the French, similar in the sense that they also allow the adjustment for economic hardship, but they don't, it's in the private law area, because you'll notice we're talking about renting a building as opposed to lighting a city. Things have changed a little in the last 3 or 4 years. The French have changed the civil code to introduce the sort of public contract rule also in private settings. So now the French follow the German example. Doesn't matter if it's public contracting or private contracting, they have a distinct different approach to the whole idea of, let's say, hardship. Why does this matter in the modern setting? Remember the claims during the Asian financial crisis as to whether people be released from contracts because suddenly the foreign exchange rates changed dramatically? Or, more recently, how do you deal with the greatly increased shipping costs that happened during the COVID pandemic? Because what happened, of course, are the contracts that were signed, say, in the 1990s, in essence, became uneconomic in Indonesia, as an example, simply because when the currency exchange rate went from, in 1995, it would be something like 2,400 to the dollar, to all the way up to 20,000 to the dollar, say 98, and then it eventually came down to 10 or 11, back up 15.5, I believe, at the moment. But the question was, were people still required to perform on contracts when the exchange rate had doubled or tripled or quadrupled? And you can go back and look at this. And do you remember what the Indonesian judges said during the 98 to 2000? You remember they approached this as a question of, people would talk about, well, is this force majeure? This is the problem. If you treated this in the German system or in the French system based on Roman law, actually they would distinguish between vis maior and what they would call casus fortuitus, which involves human activity. And they would say there's that an act of God is different from a human act, and so they would regulate it differently. Could you talk about force majeure in the common law setting? The answer is no. Force majeure for us is really a contractual concept. Force majeure exists in the civil law codes, both Germany and France. So if you didn't have a force majeure clause in your contract and you were dealing in civil law, dealing in common law, there was no release. It was an impossibility problem. What happened? Well, under those circumstances, one of my friends is actually one of the sort of civil law trained lawyers at NUS, was an expert during the Asian financial crisis arbitrations afterwards, and he told me that he would come as an expert and explain to all the common law lawyers the civil law view of change in economic hardship. They all settled the cases. They did not wish to proceed because they had thought, they were trained in the common law, that impossibility applied. No. Civil law has a very different view of how to deal with hardship. And so all the lawyers said, we don't go to arbitration, we just settle the cases. That's looking at it as a doctrinal matter. In some areas, there are differences. I already mentioned, we've talked about doctrine of frustration, improvision, which is just the French view of how this works. Professor Gautama thought Indonesian law should be governed by the French view. I think my friend at NUS told the people looking at the projects that were discontinued that actually, as a matter of sort of Indonesian law, that if they were governed by Indonesian law, and many of them were, because with state-owned enterprises hired perhaps follow Indonesian law, he said, well, you know, we have improvision in France. Indonesian law treatises show that improvision should apply, although you don't find it mentioned much outside of Professor Gautama. That's an issue where you look at the doctrine, and the sort of change circumstance comes around every years. So you had Asian financial crisis, the multi-dimensional crisis, sort of 98 through 2003. COVID comes back, 2020, 2022. Different trigger, same problem, significant economic dislocation. What do you do about whether you require people to honor contracts? I gave you the example of, let's say, the purpose of the state and its relation to individuals. We've already mentioned climate change. Let me give you another example. If we're go with public law for a moment, the same idea in Germany that as a matter of duties of the state, it owes a duty to advance, you know, the condition of individual Germans. Well, they're going back 30 years, their decisions on abortion in Germany that say the state must criminalize abortion to the extent that it has to use the strongest measures possible to discourage, to support life and discourage, let's say, discourage termination of life. And I'm not trying to make a statement. Technically, the German court said there was a duty to maintain the criminal law treatment of abortion. You couldn't just say, oh, we will decriminalize it and we will do something, you know, sort of counsel women or provide additional social support. They took the position, the German judges, that it actually required the continuation of criminal law. So one of the classic questions, for example, going back to the way I talked about views in the United States, the Germans would say you can't abolish the criminal law. We need it for support of law, support of superior interests like life. Can we abolish the criminal law in the United States as a common law jurisdiction? The answer is yes. If we have a criminal law, we have to treat everyone equally. But there's no duty to sort of prevent, let's say, to prevent actions, enactment of the criminal law. So technically speaking, we could abolish it. No elected official would want to suggest that, because next election, but there's a very significant effect of what people actually think are the duties of the state. Now, one more thing before we sort of launch into Rebecca's presentation. Go through a quick series. How much comparative law do you have to know to interpret, let's say, comparative law sources? If they come from, let's say, a jurisdiction with which you're closely affiliated, let's say in the case of India, Dutch law, well, it's probably have some vague idea about how Dutch law works, just maybe not so much in the younger generation, the older generations Dutch, so they would first go to modernized Dutch contract law if they wanted to update law. We do the same thing. For example, the courts do the same thing in terms of looking for precedents from other common law jurisdictions, say, typically from the United Kingdom, but also might look at the way another common law court in a different country is approached. That's one issue. What about the idea of sort of going further? Are you better off pursuing a question as maybe they tried to resolve it in another, let's say, middle-income country, let's say, or I don't know, maybe Vietnam or Thailand these days? Are you better looking for this sort of economically jurisdiction, or are you better off looking at, when I name India, the issue is they're actually a common law jurisdiction. Vietnam's more French in civil law, although it was socialist law for a long time. And so there are practical questions about, you don't have to pay much attention if you're looking at a jurisdiction that's sort of closely affiliated with your own. Traditionally, as a matter of sort of history. If you start getting into a discussion of, well, do we look at countries that have the same kinds of concerns, say India compared to Indonesia, you have to pay more attention to sort of technical differences if one is a common law jurisdiction and one is a. What about in certain areas like economic law? Well, as I said, they're actually the core traditional civil law jurisdiction. For reasons of economic organization, a lot of their modern law is from the common law anyway. So, I mean, from the common law jurisdictions, simply because they did things like adopted capital markets laws that came out of either the British or the Australian or the American experience. So maybe in the economic law area, it's easier to sort of assume that you can borrow from both the civil and common law simply because of the pattern that the common law jurisdictions have produced much of modern. What about public law? Well, I gave you the examples of Germany and climate change, abortion, United States, and there it seems as though the basis of the state and the relation state is much, let's say, much different. Some of the traditional civil law jurisdictions that in Europe at least would tend much more towards social democracy than some of the traditional common law jurisdictions that just have a different view of what is proper relation. Individual. So the problem is, answer to how you approach law, civil law differs in comparative. You need a certain amount of easier different areas of law because they're more different in some than in others. There tend to be differences on the public law, but it depends. Private law is roughly comparable modern economic law terms. And having said that, I think Rebecca's
Hello, everybody. I'm
Oh.
here.
Hello, Rebecca. I think we'll now, I'll quickly give you an introduction and then we'll just shift the picture to you and you can pick up giving Westlaw instruction.
Okay, that'll work.
Okay. Rebecca Maxwell is a law librarian at my university law faculty, the University of South Carolina Law School. And what I should tell you about her is when we say a law librarian, that means she studied both law and library science. So she has the equivalent of an SH, and then she has a library degree too. So she speaks in that sense with both sides of training. And she is the individual who I think does most of the Westlaw training, which we give all of our new students first year of law school. The students take a course in legal writing and research, and a lot of it's learning how to use some of the online tools like Westlaw, which I understand is available to all of you as S3. Having said that, I'll turn it over to you, Rebecca.
Thank you, Professor Lenan, and hello to everybody in Jakarta. I am glad to be with you today. I have a caveat before we start with Westlaw, because I can't get an account with your institution and you can't get an account with my institution. I'm going to have to demonstrate with the account that I can use. And the interface is going to look a little bit different. The version of Westlaw that we use at the University of South Carolina is different from the one you're using at Gajah-Mada. But the basic functionality is the same. The search techniques are going to work the same way in both versions. So please don't be disconcerted when you see an interface that doesn't look like your interface. The point I'm trying to get across is the research techniques, excuse me, and those are going to be unmute yourself and ask your question if you have one. Can everybody see my screen?
Yeah, it's visible.
Oh, thank you. This is my Westlaw interface. And I understand your subscription has access to cases and secondary sources and a lot of the same things that I have. So I am going to show you a little bit about how to move around in the databases and how to construct a search query. So here we go. The interface will let you do cases by state or cases by federal or all cases. And I'm going to conduct a search in all federal cases using terms that I think some of your research papers might be focusing on.
Could I interrupt you for a moment? Can you?
Yes, please.
Could you increase the size? It's very difficult, I think, for people to read the projection because the okay, yeah, I think now they can read it. That's better.
Yes, thank you. Any of those kinds of hints will help me as I go along to do something that you can use. Here is what our case interface looks like. Yours might look a little different. We can do all federal cases, all state cases, and of course this is focused on US law. Please excuse if you hear my dog barking. I'm not sure why she's barking. We've got options for federal states, for federal cases, state cases, and other jurisdictions. With a US subscription, we don't get very much international content, and I regret that I'm not able to show you Indonesian content. But if we're going to search all federal cases, we can ask it for whatever we want to know about once we've identified our research interest. And if I want to know what's the concept of proper and fair compensation in Indonesian law and regulation, I won't be searching for Indonesian law here because it won't give it to me. But here is how I would construct that kind of a search query. And it generally works fairly well if you ask it for what you want to know and then find out how the search engine is going to react to those terms. So if I said fair and proper compensation, and I'm putting it in quotes, so all of that will hang together as a phrase. If I didn't do that, the search engine would be looking for all of these words regardless of the relationship. It would look for fair, it would look for proper, it would look for compensation, and unfortunately, it would also look for and, which is in just about everything. So when I put the quotes around it, it looks for just that phrase, just that way. And this is what it gives me. I have got 15 cases. And they may be from lots of different courts because I've asked it for all federal. This will not get US state cases because I've asked it for federal cases. I could do the same thing in the case law database and run the same kind of search. If I wanted to throw in something, and it never hurts to ask for what you want right out of the chute. But if I wanted to get very general, fair and proper compensation is the best I can do. But since I know this paper is focused on land acquisition, I might try that too. And what I get will depend on what's in the database. Sometimes you have to play with the terminology and keep an open mind.
Could I ask a clarification question?
Yes, please.
This goes to the way I think I learned databases like Westlaw. Is it easier to search for factual situations, in other words, to talk about agrarian law, or is it easier to search for doctrine where you talk about fair compensation? In other words, should the students be focused on trying to describe a factual situation, or should they be searching by doctrine where the problem is they may have different words for the same problem? So which is better from your position?
You point up a very good point. Lots of times the concept that we come to the search engine with needs work, not necessarily because it changes the thing we want to know, but because it lets us talk to the search engine in a way that is more productive. So what I am showing you is the case law, the concept, keyword searching for case law. And this is how most people using Westlaw start out with a concept. Westlaw is good with keyword searching. I am reluctant. A lot of my students like to use what is called natural language, and they just talk to the search engine the way they would talk to a human. And that works, but lots of times you get a lot of irrelevant results. I use what is called terms and connectors searching when I can, because it lets me create a tighter relationship between the search concepts that I'm looking for. If I were to ask it for agrarian law, I would get something much broader. And it's not guaranteed in any case, no matter what term you use, how the courts or the legislatures or the originating body of whatever kind of information you're searching has talked about your term in exactly that way. And as we move on to some other databases, I will show you a little bit more about how that works. But if we have time at the end to get out of Westlaw, there are some databases that you have there for journals that this demonstrates really well in. Does that answer your question, Professor Linan?
Yes, thank you. It was just to make the distinction.
Right. And I appreciate these kinds of questions. And if you or the students have any similar questions, please let me have them and we can talk about that. I would a whole lot rather talk about something you're actually interested in. So if you're thinking it, ask it, because someone else is probably thinking it too. Notice how when I get more specific, I didn't get any cases. That doesn't mean there's nothing out there anywhere. It is one of the US legal system, legal publishing, that the only thing Westlaw and Lexis is accessing are cases that have gone through the appellate court system. There are lots of trial court cases out there, and lots of cases start and stop in the state or federal trial courts. But the vehicles for the state court system don't exist in the same way that the avenues for searching appellate court decisions exist. So there is a bit of a limitation on the coverage of the database just because there is no vehicle for the publication of state trial court opinions. Our students over here have a lot of frustration when they're researching something basic enough to know that this has to have happened before, but they're not getting anything. And the problem lots of times is that particular subject is one that doesn't get appealed very often. So if you are washing out on your search and not getting something, if you're very specific, then you start dropping terms to see what can you cut that will make the search engine give you something. So sometimes you end up with a very, very basic concept that is not as specific as what you asked for, what you really want, just because those particular terms or concepts aren't showing up in your results. And sometimes you can maneuver around that by thinking of a different way to talk about it. Fair and proper compensation may be too specific, and just fair compensation might be better in terms of what the search engine understands, or in terms of how the courts have discussed it. And if we go to fair compensation instead of fair and proper compensation, then we get a ton of cases. That's too much. Nobody wants to sift through 3,546 cases. And my version of Westlaw and your version of Westlaw will let you filter things to get something more manageable. And you can use the filters. Your filters will probably display in a different way, but there will be filters there. And the most useful filter is to consider how old you want your case law to be. If you only want very new case law, it takes it down to 248 cases, which is still a lot. But by then, you're not dealing with the thousands, and it's not quite.
Following up on having found a case that applies tells you a lot about how influential that particular case is. That's why I asked the question about shepherdizing. It ties into the idea that in the common law, focus cases, not on doctrine. Sort of what are the considered by subsequent courts to be better resolution. Sorry, I wanted to draw the tie to substantive basis of common law.
Oh, no, please keep doing that. That's great. And yes, there is a way to do that in Westlaw. When Shepard's was bought by Lexis, Westlaw had to invent its own citator service so that it could compete. And because Lexis was no longer letting Shepard's associate with Westlaw. Shepard's while it was independent, you could get to Shepard's through Lexis and through Westlaw. When Lexis' parent company bought it, Westlaw couldn't use it anymore and they had to invent something. Let me click into a case just as an example of where Westlaw's citator service is. KeyCite is the citator that Westlaw uses. You may not find a reference to KeyCite in a very obvious place on your Westlaw screen, but all of these little tabs at the top are manifestations of KeyCite information. And citing references and cited with, this is something new, and I don't quite have the confidence in it that I would have with citing references. And there's a reason for that. This particular case, and I need to find an appellate case to show you, so it'll have a more robust citing history, but this particular case comes from a district court in the US federal system, and they aren't binding precedent for anywhere, not even on themselves. So they're not the best example for KeyCite. Let me see if I can find, and this gives me an opportunity to show you the jurisdictional filter. What we want are courts of appeal. District courts are federal trial courts. They do not function as binding precedent, so they're not going to be cited very often. So if you are looking for influential cases, your best bet is going to be in the appellate system. And if I can get one, and because all of these, I have filtered these out using the last 3 years. And lots of times it takes longer than that for a case to get influential as precedent. But let's see what we've got here. And this one hasn't been cited, and this is very, very new. And it hasn't been around long enough to get cited. So what I need is one that's older than that. Okay, this one's been around for 3 years. Let's see if anybody cited that. Oh, goody. Citing references 274. So 172 cases. And just like in your system, it will tell you about the different kinds of documents that it has and how many. But 172 cases have cited to Brown versus stored value cards. So that is a quick way of finding cases that used this case as precedent. And that's a fairly easy way of getting a nice little bundle of cases that may have similar facts and legal issues to the case you started out with. I know that's a bunch of esoteric information at once. Does anybody have any questions about this feature? Thanks for bringing that up, Professor Linan. This was an excellent segue to something I was trying to figure out how to show them. Any question about searching cases? Inside the cases, it's worth looking at some of the features that Westlaw builds into the way it presents cases. West makes head notes that show you little nuggets of law that were important in how the court decided the case. And if the issue that it's talking about is of particular interest to you, you can use the head note marker to jump into the opinion and look at content that regards that issue. So it's an easy way to move around inside the document, inside the opinion, if what you're focusing on is a particular legal issue. Every head note has a number. And it will also tell you the number of cases. See, we've got 172 cases, but 98 of those cases cited Brown for the issue represented in head note 5. So that is an easy way to filter into the issues that you're most interested in. It is a good triage mechanism. And there can be just a few head notes, or there can be a lot depending on the issues in play in the case. The cases will always tell you who represented whom, where it came from, appeal from the U.S. District Court from the District of Oregon, because a case doesn't get into the appeal system without starting out at the trial level somewhere.
Ibu Rebecca?
Yeah.
Yes, thank you very much for your explanation. My name is Hodibul Umam from the program, the study program.
Hi.
I would like to say something to you that, you know, that based on your explanation, if we put the keyword into the search engine, like compensation, land acquisition, and so forth, we can get a lot of case, yeah, more than 100, more than 1,000 case. Can you give us a tip and trick how to make it easy to summarize or to correlate the case with the legal issues, for example? You know that in Indonesia, most of the legal research more focus on the law and regulation, right? It is very well that try to identify the court decision, I think. So can you give us tip and trick to make it easy? Yeah, because we find thousand or maybe hundreds information from the Westlaw. Thank you.
Yes, that is a good question, and you are absolutely right, because you find so much. So much. And let me back up out of here. When you're in Westlaw, the filters on your left-hand side are the easiest way to get a smaller number of results. We've got 14 where we started with over 3,000. And let's do this whole thing again with another topic. And I'll go into regulations this time because I know y'all are interested in regulations too. And also to demonstrate how the search engine, the search techniques work in just about any database. And I'm hoping you have some Indonesian content in some of your search engines. I don't have anything but the US content. But if I went into our federal regulations and let's try something like workers' rights. And it's not, and maybe I need to go back to cases because 7 is not, or 9 is not a lot. And also, it's going to vary depending on what kind of terminology you use. Because we're asking the search engine for something very literal. It does what we want.
Could I
Now
ask
we got
a
it.
clarification question again for the,
Yes, please.
is this a good time to go into the substantive databases because you access cases first in the regulation, but Westlaw also has I think a subcategory for labor law versus capital markets or securities laws. So if this another way for the students to limit their search is only to do it in the labor database, so why don't you try, is it possible to show them this sort of subject area databases? Because that's another way to.
Yes. And because I cannot try out the subscription that you have at Gajamada, I'm not sure it's going to be structured this way, but it's more likely than not that it is. You'll be looking for something in your interface that says practice areas. And Professor Lenan makes an excellent point. One way to get started and limit what you're going to find is to go into the practice area that's associated with the subject that you're researching. And we've got a lot of choices on the homepage in Westlaw, and you will too. But if you click on the tab for practice or the link, you're using Classic, so you may have a link instead of a tab. But if you click into the link for the practice area that you're most interested in, that is another way to limit what you're going to get. And it's a good way to see what sort of resources that the database has that is associated with the practice area that you're interested in. So let's see what we've got for employment. And there may be differences, employee benefits and general employment. So if we go in employment, we can see what kind of things the database can do for us. And when we search within a practice area, that's all we're going to get. We're not going to get things from other practice areas because the search engine has done some of the triage for you. You can ask it for anything that it presents, including secondary sources and arbitration materials and court documents, depending on what you want. You can search it all at one time, or you can search it one at a time. Yours may not do this. I find this annoying, but I can't make it stop. It will show you mine shows you the 10 most recent documents. That's never what I'm looking for, so I have to ignore it. And I'm running a phrase search for workers' rights, and I get 463 cases. That still seems like a lot. So I will go over here and see what I can adjust depending on what my search parameters are. What can I adjust? Maybe by the type of court. Most of them are coming from the district courts, which don't have very much authority as precedent. 143 of them are coming from the courts of appeal. If I care about which circuit in the Court of Appeal system, that'll cut it down a lot. And if I care about the date, I can cut it down a lot. And how you adjust the date depends on what you want in terms of currency. If you want just the very fresh cases, then maybe you want a very short time frame. If you want a longer time frame, you can get that. You can get everything they have, or you can restrict the dates. And if you want a specific date range, you can customize it. And it will let you do it. If you know a court decision was made on a particular day, you can enter that day. If you know sort of a span of years but don't know the specific date, you can enter the years and it will search just within those years. That's generally more information than I have when I go into a concept search. But one of the questions I always ask people when I'm helping them to research is, how current do you want the information? Because there are ways to get everything, and there are ways to get just the freshest cases, depending on what you want. Does this help answer the general question?
They're nodding yes.
Okay, good. That's great. Thank you. Once you get into a case, you can use all of the features that West packs on to help you figure out how usable it is. That's one of the tedious parts of doing legal research. We are talking to the search engine in a way that we think is very specific. The search engine will give us what we ask for to the best of its abilities, but then we have to go through what the results are and find out how germane each document is to what we're trying to get done. How well do the results help us answer our search query? And that's one of the reasons we don't like to start out with a whole lot. We like to bring it into a smaller number if we possibly can, because we are going to have to eventually go through them and figure out how useful these documents are. And that takes some practice to learn how to read through them efficiently. And that's one of the good things about the head notes. And if you don't want the decisions that weren't reported, and sometimes that's an issue in the US, some courts only want you to use documents that were reported, and the courts make the call about which documents, which decisions they report. And if you don't want the ones that weren't reported, you can filter them out. Reported status, if we don't want the ones that weren't reported, we can get rid of 199 cases just by doing that. But now we're back to getting district court cases. So if we filter that down only by courts of appeal, we get 126. We could get less if we date restricted it. But sooner or later, we're going to have to read the cases and decide whether they're useful for our purposes. And that's where these little head notes come in. They are summaries of the legal issues that were important in how the court decided the case. And that helps us. If we skim this, we'll get a pretty good idea of whether or not the opinion is going to be useful. And you will get a feel for this and how you like to work as you go through the process. It takes a little practice. Give yourself some time and be gentle with yourself while you get used to the process, because there is a tremendous amount of information. It took me a long time to figure out how to read cases efficiently. And in case you wonder, the real opinion, the synopsis is an editorial enhancement that Westlaw throws in there to help us. So are the head notes. All of this is stuff that the publisher uses to inform us and help us figure out the utility of the cases. When we're writing and we cite these cases in the document, we don't cite to anything out of the head notes. We don't cite to anything out of the synopsis. Where the opinion starts, when you see the judge's name, that's when you can start citing. This is the official opinion. All of the editorial enhancements are not the law. The opinion is the only thing that is the law, and the opinion starts right here. And if you see something with a flag on it, find out what the flag means. We can, since I'm hovering over this, when you see a red flag, something could have happened to the case that impairs its value as precedent. This goes back to what Professor Lenan was talking about regarding shepherdizing. The Westlaw Keysight citator has picked up on the fact that this case that we're looking at got overruled by another case. Not every red flag means something is unusable, but it does mean that it's impaired for at least one case. So when you see a red flag, investigate and find out if the case is still viable as precedent. This one is overruled. This means even if it says exactly what we wanted it to say, we're not going to use it because it's no longer good law. Once a case gets decided, it could be overruled by a subsequent case if the court decides its reasoning in the initial case wasn't sound. And this is one of the ways Westlaw keeps us from using outdated law. It will tell us about its negative history. So be on the lookout for the red flags and make sure you understand what they mean. And let's see, this is a 1982 case. The parties had to have had the court had to have had its reasons for citing a case that was overruled. But as practitioners and as scholars, unless you have a very specific purpose for citing a case that's overruled, if you want to use it as precedent, don't. Any questions?
Let me add something quickly, because you used the word precedent several times, and I thought I should repeat what that means technically. We would say that in the hierarchy of courts, which may be geographically, because when they talk about circuits, that's geographic areas, something in the United States. But precedent is a reference to a prior judicial decision. It's either binding, meaning it's from a senior court in the same geographic area, or can be simply, say, persuasive, meaning it's not technically binding, maybe it's from a different geographic area, but it's considered to be an important case because it's cited times by different judges with people. So in kind of determining importance and how they're actually in a common law system, the concept of precedent matters, and it also is how we would talk about how you decide whether a case is convincing if you're a judge, if a case is important. So it sounds like a funny word, but it's really about views of whether the case is binding as a legal matter, and it comes from a senior court in this geographic area, or it comes considered to be convincing and is cited in many different, let's say, geographic areas, and it may be merely persuasive, but that's sort of the case number sightings go up, and that's a sign that it's an influential case. But all of that is based upon our view of precedent, that courts are sometimes required to follow a senior court because it's binding precedent. Otherwise, when you say it's persuasive, you say, oh, I think that's a good judge making influential decision. And those are the kinds of draw when we talk about the source of the law comes from cases. Not that every case binds every judge. They actually judgments about how influential a case is. May bind them if it's from their geographic area, from a more senior court, but otherwise the judge has to make a decision whether to follow a different judge. Case is not binding precedent, but he just thinks it's a good articulation of the principle, so they cite it. That's why, for example, talk about shepherdizing, because if you find what you think is a precedent, try to follow it, establish how strong it is. But all of that is just to clarify, Ibu Rebecca, having used the word precedent several times, I thought you wouldn't understand that it has a technical sort of the binding case for a judge, or is it just persuasive? But if it's persuasive and it's followed a lot, then it becomes more influential. Sorry, I just wanted to make sure we're aware of what precedent means to a common law lawyer.
Thank you very much. And I appreciate these sort of enhancements and discussions. I am so steeped in some of this that I say things that I'm used to and sometimes need to back up and realize that people I'm talking to aren't necessarily used to them. So that's good. And people in the audience, if you have these kinds of questions, don't be shy, ask. Because sometimes I forget that not everybody knows the same things I'm talking about. And I apologize in advance if I do that, but do back me up and we can talk about anything that I say that you aren't familiar with the concept.
Pardon the interruption, Madam.
Yes, please.
My name is Gunawan Tauda, a student in doctoral program.
Hey.
Well, I would like to make a comment to Professor David, but first I would like to address some appreciation for this database. I think um, Westlaw database is excellent. I'm overwhelming with it, with so many sources. Nothing here in Indonesia could compare with it. I believe our own government probably doesn't even know exactly how many regulations there is in our country. Looking at this uh, database, I think there are so many sources here that could overwhelm us. An example, I just text separation of power, and then there are so many sources here. I don't even know how to start from where. So, out of curiosity, how many years does it take to complete this database? After
I
your
wish,
response,
I
I
wish I
will.
had an answer. That would involve some editorial knowledge that I don't have, or background. It might help to know that the West publishing system existed before the internet, and West was making case law, volumes of case law books for about 150 years before the internet came along. So it was not that hard for them to take their published materials and make it digital. And they continue to develop it. So West as a company has existed for much longer than Westlaw as a product has existed. And I'm not exactly sure how much time and focus they put into maintaining the databases, but they update stuff all within 24 hours. Their goal is to update things that happen within 24 hours. And of course, that means 24 hours from the time they get it from the makers. Different courts turn in their material at different rates, and different legislatures turn in their materials at different rates. But it is not unusual for Westlaw to be able to post a case one day that was decided yesterday. So they put an awful lot into it. And they've been working on the database, oh my goodness, for a long time. Before it went on the internet, it existed as disks that you had to install on your computers. I'm not sure how many people here today remember a time when you had to use floppy disk to install technology on a computer. But Westlaw is at least that old, and they've been building on it since it was a published print set. Does that help?
I think I can answer the age question. It's truly ancient because I don't know about Westlaw, but the first service was called Lexis. It's introduced when I was a law student. Because I can remember working in a summer internship, go into the law firm, and they had big kind of a printer that was about the size of a small car. It had a keyboard on it, and so the databases originally date back to the 70s, but now they push them backwards. But this actually, in terms of research, all sort of technological matters, 70s. I think it's become progressively less expensive. So now all lawyers, I think, sort of online database services like Westlaw. But when they first started in the 1970s, it was relatively more expensive. There were economic restrictions, but I think no later than the 19th American lawyer think necessary as a cost of practice. Sorry, that's just the history.
And I think there was a substantive question for you, Professor Lenan.
I think you did such a fine job. You answered all the questions already.
That would be lovely if that were true. And because we are talking about shepherdizing, this is another thing that took me a while to get my head around. This red flag goes with this case right here, Gummed Products Company. It doesn't go with Haynes Corporation. The court will tell you the law that it drew its decision from, and it will cite cases and it will cite statutes. For whatever reason, they cited one that had been overruled. I'm sure they had their reasons. Practitioners don't do it, don't use overruled cases. But when you're going through a case in Westlaw, you will find indicators of a case's status and precedential value. If there was anything going on with this case itself, you would find a flag somewhere in the early part of the display. It would be red or yellow. Red is more concerning. Yellow reflects something that happened that requires us to use caution. But there are a lot of things that get a caution flag that are just normal reactions by the court to the way the parties have tried to use the case. Let me click into this one that has been overruled. Oh, well, that's a labor board decision. See, if we had a case that had some sort of concern, West would flag it when we first come to the case. And it says, it spells out what the flag means, overruled by this other case from the National Labor Relations Board. And that's one of the things that happens in the United States. Agency boards have a quasi-judicial function and end up deciding cases based on the application of particular regulations. So you may find cases from a court, you may find cases from an agency board. Westlaw will pick them up. But if you see a case with a flag, find out what the flag means. And there will be a key cite tab for it, and it says negative treatment, which will echo what you see here. Negative treatment, if we click here, it will say what the negative treatment was. So this is a way of finding out what is viable for use and what has happened to the influence of the case that you want to use. So be on the lookout for the flags. This is something Westlaw spends a lot of time developing, so your version will have it as well. They'll be red or yellow. Yellow could mean a lot of different things. Red could mean a few different things, and none of them are particularly good. Is there any, we're almost out of time. Is there anything particular anybody wanted to see on Westlaw that we haven't covered?
The one
There are a
thing
lot.
that we,
Oh, I'm sorry, go ahead.
the one thing you haven't talked about very much, you went into the regulation database, but are there any search differences in searching statutes, regulations as opposed to cases for the benefit of the
The search queries are conducted the same way. What you get may have different filters. The content may not be as expansive because case law comes from all jurisdictions and regulations come from the federal agencies, and there are going to be a lot of them, but the publication vehicles are not as numerous. For federal regulations, you have the United States agencies making them, and for state regulations, you have the state agencies making them. And let's just run something. Oh, trying to find a good one. This may be too new to generate anything, but I'm going to use blockchain just because that is a topic of interest that I was given. That may not have been regulated very much yet because it's pretty new. 50, that's not bad. We don't have as many filters in regulations as we have in cases, but we still have ways to make it more manageable if we get a whole lot. Just because there is so much more involved in the production of case law, and West leverages so much of the information attached to cases. So regulations and statutes are not going to have as many filters. Let's go in statutes. And we can do federal and state. We're doing the United States Code. That's what this stands for, United States Code Annotated. That is the version of the United States statutory code that is published by West. They're always going to show you their own stuff first. I'll be really surprised if we have statutes on blockchain. Well, I'm surprised. And notice here is a yellow flag. If you see a yellow flag on a statute, it doesn't mean the same thing as it means on a case, because different things happen to statutes than happen to cases. Courts do react to them, but that's not the only thing the flag means. I wish Westlaw would use a different color flag for this, but they use yellow flag for proposed legislation, which is completely normal. There is no reason this should be generating a caution flag. But
So
there's a little,
it's draft legislation if it has a yellow flag?
no, they're just warning you that there is legislation in the works dealing with this subject matter.
Okay.
And just because it's interesting, we can click on this and see what the proposed legislation is. I don't know, you can't see the content until you enter it, but there are 16 pieces of proposed legislation that might affect the content and application of this statute. And this happens all the time, especially at the federal level. It changes a lot. There's always proposed legislation in the pipeline. I wish Westlaw would not designate it something abnormal, because it happens all the time. We can see what it is if we click into it, if you have that much interest.
Let me add something for the students' benefit. Proposed legislation is rancangan undang-undang. So there are apparently 16 different versions of rancangan for blockchain. Whoever asked the question.
And bound to be more, because it's becoming more and more of a national issue. And the more something gets used in practice, the more it needs to be regulated by statutes and regulations. I am so glad to have been with y'all today. And I don't want to keep you any later than you were expecting to stay, but if you have questions, I am glad to answer them. Or if you have something you want to see more, I would be glad to show you.
Actually, I have a question for Professor David. You allow me? First, about legal convergence. Does it really happen in our global law system? That's the first question. And then the second one is, I'm curious about court decisions in the United States. How often does the judges construct their decisions based on regulations?
With regard to legal convergence, it sounds impressive, but it's much easier to converge via statute because different, let's say, legislatures can borrow statutes from other countries. So one version of legal convergence might be what I mentioned when you saw the civil law countries adopting capital markets laws from the common law countries, using them as models. Legal convergence is probably less less common in case law, and it also would be less common probably in public law. You might say, well, everyone has the same idea about rights, but that's not actually. There are differences of opinion. And so it's much easier to see convergence in specific statutory areas because everyone has to deal with similar economic problems if you have a capital market. But you know, if the question is instead how to deal with, I don't know, abortion or climate change, well, the answer is the United States and Germany will not converge because the Germany has a different view of the role of the state and what duties the state owes to individuals than for American public law. So there's convergence in some areas. It's probably easier to find in private law areas, but in public law areas, uh, what is it, for example, Article Constitution? I mean, it keeps changing, my experience, so it's difficult to even talk about a convergence on article. So why should other countries sort of try to adopt and kind of reach on what it? But that's an example where there are differing ideas in the public law area about what is sort of the relationship state and people. Private law, it's much. And I think, what was the second question?
How often does judges in the US construct verdicts based on regulations than their other decisions from the judges or other verdict from previous judges in similar case?
It depends very much on the area of law because, for example, in criminal law, we would say the judges are supposed to very narrowly follow the criminal law statute. So they would construct their decisions based upon the statutes. If you were talking about traditional private law areas like contract law, torts law, property law, most of that is still common law, meaning it's not it may be codified, but a lot of private law is still in judicial decision, and so if you're talking about certain areas of the law, it's all following legislation and rules. Typically in the economic area, antitrust law, capital markets law. In private law areas like property and contract, much more likely they're still following simply because of the way our law is organized.
Thank you.
Thank you. We don't want to keep you any longer than necessary, Rebecca. So unless there are any further questions, I think should release you work in the morning.
It was my pleasure being with y'all. Thank you very much.
Thank you.
Okay.